Hello everyone. This is a webinar regarding a guideline for taxation on non-resident enterprises in China. This webinar is sponsored by EU SME Center. The center is a EU Commission-funded project which helps EU SMEs prepare to do business in China by providing them with a range of information, advice, training, and support services. The center is implemented by a consortium of 6 partners and was established in October 2010. It successfully completed its first phase in July 2014 and has now entered in its second phase, which will run until July 2018. For myself as a speaker, I was graduated from Law School of Peking University and started my professional career as tax advisor in PwC Beijing office since 2002, and later joined some local tax firms, worked as tax partner, providing tax professional services. I obtained the CI/CPA qualification, China nationwide lawyer, and CFA qualifications, and in my professional lives, I have provided tax advisory and tax agency services for the overseas companies who was making investment in China or doing projects in China, getting incomes in China for such kind of cross-border transactions, and accumulated relevant experiences in this area. So today I will share some of my experience and the tax administration systems in China regarding the non-resident enterprises. And this is our agenda today. First of all, we will discuss the non-resident enterprise, the concept, and also the relevant income tax they will get from China. Non-resident enterprise, it is a concept which is in contrast with resident enterprise. What is non-resident enterprise? From the legal interpretation, non-resident enterprise is incorporated under foreign law other than China company law. This is the first criteria. And the second is actual management is located abroad, not located in China. I think maybe a lot of foreign companies, they are incorporated under foreign law and the actual management is not in China. But the key factor is they may have some incomes generated from China, which or they has a permanent establishment. We will call it a PE. They will either has a PE in China or generate incomes with Chinese source. That's the key factor. Only when they have such kind of income in China, they will have connection with the tax system in China. So to give you a whole picture of the China tax administration system on non-resident enterprises, I will first let you distinguish the 4 kinds of income. First is active income, and the second is passive income. What is active income? Basically, we call it a business profit. It's generated from some active business activities, for example, trading of goods or rendering of services. In today's webinar, we are talking about the service income generated from China. What will be the tax implication for this? And for such kind of active income, they will have close connection with what we call an establishment or a PE in China. The basic taxation principle is if you have a PE in China, the China tax authority will have the taxation power on the income. If you doesn't have a PE in China, or you will have the tax treaty protection, and there will be no income tax in China. And the income tax rate is 25%. Corporate income tax rate is the standard tax rate in China on the profit. Normally, in some circumstances, The non-tax resident enterprise only have its gross revenue, but cannot provide the actual profit in China. So the profit is unable to be calculated. Then the China Tax Authority will adopt a deemed profit rate to assess the total taxable income, and the deemed profit rate is ranged from 15% to 50% on the gross service income generated from China. On the contrary, passive income. What is passive income? Passive income are incomes connected with certain legal rights and doesn't have close connection with business activities in China. So, for example, dividend, interest, royalty, rental, capital gain. That's the major types of passive incomes. So dividend has close connection with the shareholders' equity in a company in China. For interest income, it has close connection with loan or usage of fund. For royalty, it has connection with usage of intangible assets, and for rental, it has connection with usage of physical assets, including equipment, real estate, and other physical assets. For capital gain, it has a connection with the proprietorship of assets and the company equities. When you transfer the assets or transfer equity to another company or another individual, you will get some capital gains. So it has connection with this. So basically, we see for these major types of passive income, they have close connection with certain legal rights, and doesn't has close connection with active services. So that's the key factors, and also due to this, it does not has close connection with whether the non-resident has a establishment or permanent establishment in China. So the taxation principle on passive income, the tax authority will not assess whether you have a PE in China, but instead they will assess whether you have the Chinese source of income, this kinds of passive income. And also the tax treaty protection is not saying you have a PE or not have a PE. It says it will offer a lower tax rate, or it says there is some tax exemption by its restriction of the sourcing country's taxation right. The sourcing country here refers to the Chinese government. And also for the passive income, the standard CIT treatment is 10% withholding income tax rate, or we normally call it withholding income tax. The tax rate is different from the standard 25% corporate income tax on the profit. So above all, you need to distinguish what kind of income you are generating from China. Is it in nature of active income, or is a passive income, since the tax treatment and tax treaty benefit and the tax administration measures will be different. In this webinar, we will focus on the corporate income tax, the CIT, but you should know that in China, if you are generating incomes from China, there may be some other taxes, and in China we have the value-added tax, or called VAT. VAT, the basic principle is either the service provider or the service recipient, whichever is located in China, then the China Tax Authority can impose VAT on such service income, unless the service is totally rendered outside of China. But how to distinguish whether the service is totally rendered in China is very complex and is not covered in this webinar. And for import of physical goods, the VAT shall be paid by the buyer, the Chinese buyer, instead of non-resident enterprises. So if you are selling goods to China, to the buyers located in China, you don't worry about the VAT. For VAT, there is no tax treaty protection, and also for VAT there are some local surcharges which we may call the city construction tax, called local educational surcharge, and something else. It varies from location to location. Will be such surcharges will be levied on the VAT amount paid. So you should know, apart from CIT, there are some VAT implications in China. Also, if you're dispatching some people working in China, you know, in most of tax treaties, if they stay in China for more than 183 days in the calendar year, or your project in China has constituted a PE, these people will be subject to China individual income tax for their salary incomes. So there are also some personal taxes on the people who are working in China. And also there is stamp duty is applicable to the sales contract, the service contract, which is executed in China. Also there are some other taxes, so you should know, apart from the income tax, corporate income tax, there are still some other taxes you should be aware of. And this is a table which summarizes the tax treatment for cross-border incomes. First is service income. Service income in nature, it is active income, and the taxation principle is whether there is a PE in China. For the tax treaty protection, is for PE or non-PE. It has not connection with what beneficial owner. We will talk with it about later. What is the beneficial owner? And the applicable tax rate 25% based on deemed profit rate. Yeah, and for dividend, it's passive income. It's not have any connection with the PE. It for all the passive incomes apart from capital gain, you should know our concept of beneficial owner, so, which says whether it's a tax concept. It will tell whether the non-resident who receiving passive income from China is really the beneficial owner of such kind of income, to avoid the abuse of tax treaty benefits. And that's something we will talk about later. The default income tax rate is withholding income tax at 10%, and the tax treaty benefit is reduced tax rate, maybe reduced from 10% to 5%, 6%, and some others. Interest income, also passive income, and is similar as dividend. Maybe one difference is for dividend there is no VAT, but for interest income there is VAT, 6% on the interest income. For royalty, it's passive income, but if royalty is connected with a service PE, the tax treaty and the local tax regulation require the royalty income will be bundled with the PE and treated as active income. If it's not related to a PE in China, it's treated as passive income. And also the tax treaty can offer a reduced tax rate of benefit. For rental, it's passive income, and also standard rate is 10%. The tax treaty benefit can offer a reduced tax rate. For capital gain, it's passive income and it doesn't has connection with the beneficial owner. And the standard tax rate is 10%. The tax treaty benefit will not offer a lower tax rate, but only restriction on the taxation power. Some tax treaty says only the home country has the taxation power, and some tax treaty says the source country has the taxation power. So it didn't offer the reduced tax rate, but it offers restriction on the taxation right from the home country. So that you should remember this table, and this table summarizes most of the cross-border income and their tax treatment. And the next step, we will talk about the PE and the service income. Remember, the PE has connection with active incomes and in most of the case, the service income you are generated from the source country. Source country here we are talking about, since we are talking about non-resident who receive income from China. So China is the source country, and your home country in Europe, maybe Germany, maybe France, and maybe Switzerland, and you are located in the home country. You are the non-resident from home country, receive income from source country. The source country is China. So what is the purpose of PE? Basically speaking, the purpose of PE is to distinguish the taxation right from the home country or the source country. The basic principle is, if there is a PE in the source country, in China, so the China tax authority have the taxation right. If not, there's no income tax in China, and as you are the tax resident in the home country, you should pay income tax back to the home country. So that's the basic principle. PE refers to a fixed place for business. This is the basic concept. The basic concept, fixed place for business. So what is a fixed place for business? Yeah, from the tax treaty and the China tax regulation, there are 4 types of PE. The first is the fixed place PE. Just as the concept is a fixed place for business purpose. For example, if a non-resident enterprise set up a foreign desk in a Chinese domestic company to do some business liaison, contract, local marketing, contract negotiation, and such kind of things, this foreign desk is a fixed place and is for business purpose. So technically speaking, it can be regarded as a fixed place PE. Another typical example is a representative office. A lot of foreign companies, when they start their business in China, they do not want to invest a fund at the very beginning, since if you set up a company, you need to pay in capital. But for setting up a representative office, there's no capital requirement. So for some foreign companies, the first step for they to explore the China market, they may set up a representative office here. Based on the local regulation, a representative office is unable to generate any business income in China. It can only provide local liaison service and the marketing service for the head office. But from the China tax regulation, the representative office should pay corporate income tax. Why? So from the tax concept, the representative's office is treated as a fixed place PE of the overseas company. So it's a PE in China, and also its activities has some contribution to the home office. So from the tax perspective, you will see the PE or the rep office has contribution on the parent company's profit making from China, since the parent company or the head office will provide services or sell goods to the local customers and getting profit from China. So from tax perspective, such PE has contribution to such business profit. So that's why the representative office is required to pay income tax, and basically the China tax authority adopt the cost plus method to require the representative office to pay income tax. The cost plus method is using the operating incomes incurred by the representative office to calculate its taxable income. So the basic principle and the methodology here is a representative office is treated as fixed place PE. And let's just step a little back. Well, whether PE, if there's a PE, the China Tax Authority has the taxation power, and also the standard tax rate 25%. And if the actual profit can be provided, okay, then you can pay income tax on the actual income. In China, there is such kind of representative office, the representative office from a law office. It pay corporate income tax based on its actual profit. But for some other representative offices, they are unable to tell what is their actual profit. So the tax authority use the cost plus method to calculate it and use a deemed profit rate. For rep office is normally 15%, and for other kind of PE, the deemed profit rate ranges from 15 to 50% on the gross income. So that's it. Another PE type is a construction PE, which means a non-resident enterprise is undertaking a construction project in China, and based on most of the tax treaties, it requires the construction project duration normally exceeded 6 months. So if a non-resident enterprise undertake a construction project which is more than 6 months duration in China, it will constitute a construction PE and also will pay corporate income tax in China. Construction PE is only limits to the activities with constructions, installations, but another kind of PE, service PE, is range is much broader, rendering onshore services with a duration exceeding 183 days in China in any 12-month period by dispatching people working on the project site, onshore project site. It will constitute a service PE. So for service PE, there are some points you should be aware. Firstly, 183 days, how to count it. There is a basic principle, anyone here, 1 day. If there is one guy working here for the service project, then it will be counted as 1 day. If you have 2 people, 3 people on the same day here, there is some overlapping. It will still be counted as 1 day. And maybe in certain day there is nobody here, and then this day can be excluded. This is how to count the 183 days, and how long. Within how long a period the 183 days will be calculated is within any 12-month period. Please be aware and pay attention to this. It's not in a calendar year. It's in any 12 months period. We can call it a rolling 12-month period. For example, from March to February of next year, from April to March of next year is rolling of any 12-month period. It's not in a calendar year. So we should pay attention to this. And here the scope is much broader. Not only construction activities, but professional services such as engineering, technical service, management service, design, training, consulting services. All kinds of such professional services should be treated in this service PE. And also, in some services duration, there are some non-resident enterprise. They say, okay, we undertake such service project, but we may not send our employee for it. We will use some freelancer. freelancer is not my employee. But here, for recognition of a service PE, the tax authority will not distinguish whether it is the employee of the non-resident or it's freelancer of the non-resident enterprise. They will not distinguish. They just see who this guy is working for. This guy is working for which company? Okay, we call it working under the umbrella of this non-resident enterprise. So these guys will all be counted into the 183 days. So that's something you should be aware of. In what circumstance will there will be a service PE. There's the fourth type of PE is called agency PE. If a business agent in China habitually exercises authority to conclude contracts on behalf of the non-resident enterprise, this business agent will be treated as an agency PE here in China. In some representative office case, that according to China regulations, the representative office can only provide local liaison and marketing services, but in the real life, some guys in the rep office, they are doing the business activities. They are negotiation contracts for the overseas head office, and can determine the key factors of a contract. For example, the contract price, the volume, and how to deliver, when to deliver, and anything such key clauses of a contract. Yeah, if this being the case, technically speaking, the rep office is not only a fixed place in China, but also an agency PE in China. For a fixed place PE in China, we already talked about it. The taxation basic principle is the cost plus method, based on the rep office operating expense incurred. However, if it is treated as an agency PE, the taxation base is the incomes which is attributable to the business activities of the agent. So technically speaking, the tax risk for an agency PE is much more higher for agency PE case. So that's something you should avoid in your business activities in practice. Another example for agency PE is the employee secondment. It's quite common. So for parent company, it has a Chinese subsidiary, maybe a WFI or joint venture. It doesn't matter. The parent company may dispatch some expatriate employees working in the Chinese subsidiaries. Normally, it's maybe some high management in the Chinese subsidiary, general manager, or some other management guys. For the expatriate people himself, he will say, okay, I can work in China, but I want to keep my employment relationship with the parent company, and I want to pay social securities in the parent company in the home country, and I want to have my salary payment in euro or in US dollar, and I don't want renminbi here, and also I don't want to be binded with the local labor law here. That's quite common. But what will happen in this arrangement? Yeah, the parent company will have a relationship of employment with this guy, and then sign a employee secondment agreement with the local subsidiary to dispatch the people working in the local subsidiary. And every month, the parent company will pay the salary to this individual. But as his actual working location is in China, in the Chinese subsidiary, his labor cost should be borne by the local subsidiary. So the parent companies will send the invoice to the Chinese subsidiary to reimbursement of the salary payment back to overseas. But China is a country with a very strict foreign exchange control. When the local subsidiary claim to pay it either in euro or in US dollar to the parent company, the tax authority will appear and will say what kind of income you are paying to the parent company. You may argue it is only reimbursement of the salary which is paid by the parent company but should be borne by the local subsidiary. But the tax bureau will challenge, is this expatriate? Is he totally working for the local subsidiary? Did he constituted an agency in China? If he working in the local subsidiary but is still controlled by the overseas parent company, and his activities can represent the parent company, signing the business contracts, doing business activities, his activities can be regarded as agent of the parent company and will constitute, since he stayed in China for a very long time, it will be regarded as an agency PE if there is an agency PE, as I have mentioned. Such kind of payment will be not only be regarded as purely salary reimbursement, it will be regarded as service fee. It means the local subsidiary is paying service fee for the business activities undertaken by this expatriate to the parent company, as the parent company is this guy's employer, and pay the salary to this guy. So the nature of the payment will change. The tax bureau will regard it as service fee. If it is in nature of a service fee, then the tax bureau will impose income tax and also VAT on the payment. So that's something I would like to alert the EU SME members. If you are trying to arrange such kind of employee secondment with the Chinese local subsidiary, please pay much attention on the contract clause and a lot of things. Maybe you need to consult with the tax advisor whether you should do it or how to do it to mitigate the tax risks. In much of cases, I encountered that it's the overseas parent company will feel very surprised. How can this be? But I should tell you, you should understand what is the taxation system and the taxation methodology here in the China tax authorities, what they view the transaction. So you should do this everything right at the very beginning, not after what everything is done you feel is quite surprised. It's not a good way to do your things here. After the passive incomes, we will talk about the passive income. So passive incomes, dividend, interest, royalty, rental. As we have mentioned, the tax treaty will offer a lower tax rate. The standard tax rate is 10% withholding income tax rate, but there are some lower tax rate, 5%, 6%, or 7%, or some other tax rates. You should know. But there are some criteria. Remember, for the first of all, the non-resident enterprise receiving dividend, interest, royalty, or rental payment should be a beneficial owner of this passive incomes or beneficial owner, we will interpret the concept later. And also for dividend, for example, if in some tax treaties it require if the foreign company's shareholding is above 25% and the shareholding period is more than 12 months, okay, the tax rate could be reduced to 5%. A common practice in the past years for some Europe companies, they like to set up a Hong Kong holding companies as a first step, and then the Hong Kong company, we call the Hong Kong Intermediate Holding Company, then later set up a joint venture or a WFI here in China. It's quite common before, since the double tax treaty between the mainland China and Hong Kong, it says if the shareholding percentage is more than 25%, the tax rate could be reduced to 5%. And some Europe companies, they view their home country doesn't have such a good tax treaty with China government, so they want to use Hong Kong as an intermediate holding company to better organize the shareholding structure and to get the tax treaty benefit. But in recent years, the China tax authorities are paying more attention to this. They say it's not the Hong Kong company is a conduit company or only a share company. They didn't view it as a real company with business substance. So they say you are trying to abuse the tax treaty benefit, and we will not grant the tax treaty benefit between mainland China and Hong Kong, and just adopt the standard tax rate of 10%. So here we need to talk about the beneficial owners. What is a beneficial owner? Beneficial owner is an entity or individual that has ownership and control over the passive incomes, royalty, dividend, interest, such things. So the China tax regulations emphasize that a beneficial owner should have real business substance. What is real business substance? For instance, in the case I just mentioned, the Hong Kong company should have manufacturing, trading, management activities, or have active business operations. It cannot be only a purely shareholding companies. If it is only a purely shareholding companies, Chinese tax authorities may challenge whether it is a beneficial owner by saying, okay, it doesn't have any real business substance. If the Hong Kong company doesn't have the business substance and are denied its beneficial ownership, the tax bureau will directly adopt a 10% withholding income tax rate other than the tax treaty benefit, the reduced income tax rate. So that's something you should know. From tax perspective, setting up a Hong Kong intermediate holding company may not be workable in the practice of taxation. Similarly, for interest, some tax treaty offers a tax exemption for certain listed financial institutions or offer a reduced income tax rate, back 7%. And also here is a case back-to-back loan. For example, using a Hong Kong institution to make a loan to the Chinese debtor, but actually the fund is not offered by the Hong Kong institution. It is offered by a European institution. So the Hong Kong company, the Hong Kong institution only offer a back-to-back loan to the debtors located in China. Similarly, if the China tax authority detects such arrangement, it will also deny the beneficial ownership of the Hong Kong institution and require to use the 10% withholding income tax directly. Royalty is in connection with usage of intangible assets. Intangible assets including patent, trademark, copyright, know-how, franchise, and other intangibles. Similarly, with the back-to-back loan, there are some sub-license agreement. For example, use a Hong Kong company to you license some royalty to a Hong Kong company, and the Hong Kong company sub-license this to the Chinese user. This arrangement is also trying to leverage the tax treaty benefit between mainland China and Hong Kong. And also, if the China tax authority detects the Hong Kong company doesn't have any business substance, it will deny it and adopt the 10% withholding income tax rate directly. Rental is here refers to equipment rental. For equipment rental is listed as royalty in most of the tax treaties, and basically there is no tax treaty benefit for real estate rental. So for royalty, need to discuss it, since in most of the real cases we encountered before, some foreign companies they are signing some design, engineering, R&D contracts with a local customer. They will provide some design, R&D services to the local buyer and will receive such incomes. But from tax perspective, how to distinguish such income from royalty to service income? Basically, if it is classified as service income, for service income, the basic taxation principle you remember is whether there is some PE in China. And in most of these cases, there's no PE. So for the China tax authority, they cannot impose income tax on it. But most of the tax authorities, their habits, they want to impose the taxes as much as possible. So they will say, okay, you are signing a R&D contract with it. So for the R&D activities, you will have some products, some IP rights. And what will be the treatment on such IP right? Will the R&D service provider own the IP right? If yes, tax authority will say it's not purely a R&D service, it's some kind of royalty, since you maintained property of intangible, and they will regard the income you charged to the local customer as some kind of license fee or royalty. If it is classified as royalty, since the nature is changed into passive income, then the 10% withholding income tax can be used, and there's no treaty protection on PE. So that you will see the taxation changed a lot, and in the real case, a lot of foreign companies suffered from such kind of reclassification. They think they are providing services to the local customer, but when they claim payment from the local customer, the in-charge tax authority says it's not service income, it's royalty, and they impose 10% withholding income tax. It increased the tax burden to the non-resident enterprise. So here, I have to emphasize that it would be advisable for you to do it right at the very beginning in the contract to avoid any tax surprise later. So from the China tax regulation, how to differentiate a royalty to service income, there are some basic rules. Firstly, whether the income has connection with intangibles. It says if the service has connection with certain technology or know-how that is necessary for production or copy of processing a product which has not been disclosed to public, it can be treated as royalty. And also the nature is passive income. They said the non-resident enterprise is only a licensor, so it will not participate in the specific application of the technology and will not guarantee the outcome. And another thing is confidentiality, since royalty normally has connection with certain technology, certain secret, and it will require the confidentiality in the contract. But in practice, we observed that some tax law authorities here, they view confidentiality as a key factor. They see, okay, if in your contract there is confidentiality, I will regard it as a royalty. I will not distinguish it from service income. It is confidentiality. There is some error in their logic, but I have to let you know the risk here. Another thing is the IP right ownership. If the service provider still keep the ownership of such product, it means you will license it to the recipient here, or will license to some other recipient. So the tax bureau will say, okay, you have the IP right, you can license it, so how can you say it is purely service income? I say it is royalty. Yeah, that is the question, and that is the problem. You need to know in advance, so you need to do it right to mitigate your tax risk. So that's something you should know. You should avoid these things before you sign the contract with the local customer. Another thing is capital gain. For capital gain, it doesn't have connection with beneficial owner, but it has connection with from selling what kind of property you get the capital gain. The standard treatment is 10% withholding income tax rate, no difference from others. Yeah, but there is some difference from selling real estate or selling equity. So if you are transfer a real estate which is located in China, absolutely the China tax authority has the taxation right. But in some transactions, the transaction is packaged as transfer of a company. But the company, if you look at the balance sheet of the company, more than 50% of the company's assets is constituted as by real estate. So there is such tax avoidance clause in the tax treaty. It's called such company as a real estate company, since its assets is mostly constituted by real estate. If this being the case, the China Tax Bureau will say, okay, you are transferring a real estate company, I still have the taxation right. For transfer a company in a normal Chinese company, the taxation rule is, in some tax treaties, the capital gain could be taxed only when the shareholding portion is more than 25% in the past 12 months. In some tax treaties, the taxation right is absolutely entitled to the sourcing country. Yeah, that is entitled to the Chinese tax authority. But in some tax treaties, the taxation right is absolutely entitled to the home country. Is your home country in the Europe, so you should refer to the applicable double tax treaty to find what is the tax treatment. That is direct transfer, and in real cases there are lots of indirect transfer. In this chart, you will see company A hold a company B. Company B has a subsidiary in China. It's company C. If company B transfers the equity to company C to another buyer, the local government will be aware, since company C will change its business license and the tax registration, and the local government will be aware of it, and the tax authority will come to company C, or you changed your shareholder, then your shareholder will have obligation to pay withholding income tax here. But if company A transfer equity of company B to the buyer, there are no change on company C's shareholding structures, and the local government will not be aware. But the ultimate controlling rights has been changed. So that is anti-avoidance tax regulation since 2009. Transfer of a foreign company which directly or indirectly hold equity interest or real estate in an underlying Chinese company. And then the China tax authority, if they get information of such kind of indirect transfer, they will launch anti-avoidance procedure and to see whether there is substance of company B. If there is no substance of company B, they will regard it as company A is transferring equity of company C, so they will impose withholding income tax to this transaction. And there are some criteria saying in what circumstance it can be regarded as without reasonable commercial purpose. For example, 75% or more of the value of company B is derived from company C, and 90% or more of the total assets of company B is directly or indirectly derived from the assets in company C. And company B performs limited functions and undertake limited risks, and which is not commensurated to their business substance. And another thing is, foreign income tax payable for the indirect transfer is less than the possible tax burden in China or similar direct transfer. Yeah, if you look at most of publications of China tax authorities, they will say that they are paying much more efforts since 2009 to now. Every year, there are many cases they detected for such kind of indirect equity transfer, and in each case the tax implication amount will be huge, normally millions of dollars or even more. So if you are doing some company reorganization, or you just or selling your business in China, you should pay attention to this regulation. Not just saying company B is okay. You're saying I'm totally doing an overseas transfer, doesn't have any connection with the China tax authority. It's not the story. The China local tax authorities will try their best to detect such transactions and levy the taxes. Okay, next step we'll talk about the tax treaty benefits. Yeah, it has connections with the beneficial ownership. We have been saying local tax authority, when the non-resident enterprise applying for tax treaty benefit, their response will say, okay, you are trying to apply for tax treaty benefit. I will detect whether you have the beneficial ownership, and what are the factors they will assess whether the non-resident have the beneficial ownership or not. There are the criteria. In this table, you will find there are 7 risks. For example, no control. The intermediate holding company that doesn't have control over the income. It has no operation. It doesn't have any operation. It has very low asset and very few personnel. It undertakes no risk and paying no tax or very low tax, and also for the back-to-back loan, for the sub-license arrangement, the China tax authorities will challenge whether this company is the beneficial owner. So if you want to apply for the lower tax rate provided by the tax treaty, please assess yourself whether your arrangement in this passive income, for example, royalty, loan interest, or just dividend, whether they are within the criteria set by local tax authorities. If after assessment you think the possibility for evidencing the beneficial ownership is very, very low, then you can just say, oh, okay, I will forget it. I just above the 10% withholding income tax directly. Yeah, that is the tax clearance procedure. As we have mentioned, China is a country has very strict foreign exchange control. So for the local companies, whether the local subsidiaries or the local customers, they want to effect the payment to you, they need to fulfill certain formalities. Firstly is contract registration. Normally it is said within 30 days upon conclusion of the service contract, the Chinese buyer should register the contract with the local tax authorities. If not, the tax authority can impose some penalties on the local buyers. And then the tax authority will assess what will be the tax implications. And at this stage, you, as the non-resident enterprise, you have to apply for. If you want to enjoy the tax treat benefit, you must come here to say, okay, I want to enjoy tax benefit. Since the basic taxation principle is, if you doesn't claim tax treaty benefit, the default tax treatment will be applied. For service income, it will default. The default status is you have a PE. For passive income, the default treatment is 10% withholding income tax. And remember that your local customer, they want to reduce their tax risk, tax withholding risk. If you didn't claim the tax treaty benefit, they will adopt the standard tax treatment. And for them, the standard tax treatment could reduce their own tax risk, but increase your tax burden. So basically, based on our experience, the local customer will not help you doing so unless you insist. So that's something you should know. You should know if you want to reduce your tax burden in this transaction, you must claim it to this, and also you need assistance from the local customer and also maybe your local tax advisor. Since your local Chinese buyer, they may not have sufficient knowledge and experience to deal with the local tax authorities. And later, after tax assessment, the tax authority says, okay, we agree you to withhold certain VAT and certain withholding income tax. And when the contract payment is due, the local customer will withhold the taxes from the payment and pay the tax to the tax authorities. After this, they can pay the remaining balance to you. But when they go to the bank will say there's a regulation set by the tax authority and we call the Foreign Exchange Administration. They said one single payment above $50K. If there is such kind of payment, you must obtain a tax clearance record filing form from the tax authorities. Otherwise, the bank say we cannot effect the payment. So if the one single payment is below the threshold of $50K, okay, that's okay. You can go to the bank, ask your Chinese customer to pay it directly. But if the payment amount is above this threshold, you will still go to the tax authority, ask them to issue the tax clearance form, and then the bank of the local customer can effect the payment. So that's what we say. The whole process is complex, and based on our experience, the procedure will take at least 2 or 3 months to have all these things done if everything is smoothly carried out. And at last, we'll talk about anti-avoidance measures. Since during the beneficial ownership and the indirect equity transfer, we have already touched the concept of this. Now the China tax authorities are paying more attention to the anti-avoidance. They are saying the non-resident enterprises, they may abuse the tax treaty benefit and reduce the China tax payment here, and that's something we cannot tolerate. So that's something we should know. Basically, for the anti-avoidance, we just introduced two major areas. First is the transfer pricing. For EU SME enterprises, you may have subsidiary here, and if the equity holding percentage is more than 25% from China tax perspective, you can be treated as related parties. And for related parties, you may have transactions, for example, rendering services, selling goods, and such things. There, the basic principle is the arm's length principle. It requires you to refer to the principles adopted by unrelated parties when conducting similar business transactions. So if you want to transfer some profit from China to overseas countries by selling something on a very high price or buying something on very low prices, the China tax authority will say, okay, such transaction is not on arm's length principle. We will not permit it, and they will assess a reasonable profit margin for the local company and adjust the price, and based on this adjusted price to impose the corporate income tax on this. And also the tax authority can claim the underpayment together with late payment interest. So if you are having a lot of cross-border transactions with local related party here, you should pay attention to the transfer pricing, and there are a lot of reporting formalities on the related party transactions, especially for the cross-border transactions, which you should be alerted. Another thing is intra-group charges. Based on our experience, it's quite common. The overseas parent company, they like to allocate its back office costs to the overseas subsidiaries. Since some parent companies, they have the basic idea, the back office here of the finance, the treasury, the IT, the R&D department also, they not only provide the services to the parent company itself, they also give benefits to the overseas subsidiaries. So they also provide services to them. So their cost cannot be borne by the parent company solely. The parent company want to allocate the expenses to the overseas related party, but the China tax authority says such payment to overseas related parties which doesn't undertake functions, bear risks, and has no substance operations shall not be deductible for CIT purpose. Which means, okay, you can pay it, but after the payment, the tax bureau will double check whether the payment is reasonable. If the payment is not reasonable, they will say, even you pay it out, you cannot deduct such expenses from income tax perspective. This is a penalty, right? Another thing is royalty. For royalty payment to overseas related party, if the overseas related party only have the legal right of the intangible assets, but has no contribution to the value creation, such a royalty payment could also be regarded as not in compliance with the arm's length principle and non-deductible for CIT purpose. So it's something we should let you know. It's very important. Such regulation was issued by the local tax authority, by the China tax authority in 2015. It has been effective for around 2 years. So if you are still doing these things, such kind of allocation of back office expenses or royalty hold royalty in some in some shell company located in tax haven. The China tax authority is now trying to challenge such payment. They are not challenged on the realness of the transaction. They are not saying the transaction is not real. In the anti-avoidance area, the tax authority, they are not challenging the authenticity of the transaction, but they are challenging the reasonableness and challenging the pricing policy, whether you are transferring price or transferring profits to overseas entities or even transfer it to tax havens. That's the things. Maybe you know the BEPS, the base erosion and profit shifting is a large project launched by G20 and OECD. They want globally they want to avoid the multinational companies using some SPVs set up in the tax havens or using some vehicles to avoid the tax payment. So it's now the trend of tax administration globally. You should pay attention to this, and our observation is the local tax authority in China, they are stepping forward with the global trend, and they are putting much more efforts on the anti-avoidance on the cross-border transaction tax administrations. So that's our webinar today. There are some related publications. You can refer to this slide. There are some tax libraries and some publications provided by the EU SME Center, which could be for your reference. And also, if you have any questions, you can contact the center for the guideline. There is a full version of paperwork of this guideline. You can refer to it for much more details. And also, if you have specific questions for your own company, you can contact me via the EU SME Center for your questions. Oh, thank you for your time.